I'd like to introduce our panelists. So first, I'll introduce Dr. Lachlan Caunt. He's an adjunct professor and Tim Bates Postdoctoral Fellow at Queen's University. He's the director of the Better Justice Lab, an access to justice nonprofit based in BC. He's been teaching at UBC since 2017 and recently was a visiting academic at Keble College in Oxford. So Lachlan, if you just want to talk briefly about some of the work that you're doing.
Sure. So I've been sort of snared into computational linguistics and data science in the last couple of years in sort of an unexpected way. I'm a lawyer and a legal academic, and I never thought that I would be as innovative as I sort of seem to be now. But what primary usage I'm having right now for this sort of interesting, exciting field in the law is through an organization called the Better Justice Lab, which I'm the director of. And the Better Justice Lab is a BC access to justice not-for-profit. So when I say that, basically we're trying to connect people with legal solutions to their legal problems is what we're attempting to do. That's sort of what access to justice means. Many people think it means connecting you to a lawyer, which is seldom true. And I'm happy to speak a lot more about that further down the line. But basically what we're doing is we have a data-driven lab where we're attempting to work out what problems exist in Canada's legal space. Pretty much everything that's being done in access to justice in Canada is anecdotal. People gather together and say, you know what I think is a capital idea? I think it's a capital idea to do X or Y or Z. And then people get funding for it and implement it. And sometimes it works and sometimes it doesn't. But none of it is data driven. So what we're using natural language processing for is the first half of our lab, which we call the Data Analytics Lab. And we might have some members of this data analytics lab on the Zoom call today. I'm just scanning through names to see. Perhaps not yet, but we've actually hired multiple students from the UBC MDS program to work in the data analytics part of the lab. And what we're currently doing is we're using Google Analytics to work out exactly where people are going. So when they have a legal problem, what are they Googling? And then where are they ending up? And we're tracing them to where they end up. And then we're using natural language processing to basically interrogate what sort of questions they're asking. Are they asking questions about housing? Are they asking questions about employment? Are they asking questions about consumer issues, about finance, about family law, about criminal law questions? And as a result of that, we're able to actually, maybe for the first time in British Columbia, work out what access to justice needs exist in relation to the general population. We're looking at the people that aren't going to lawyers. We're just looking at the people that may have a simple legal problem. You know, their mattress broke or their employer had put them on leave when they didn't want it. Basic legal problems, not I'm going to jail for 50 years, just simple, common, everyday legal problems. And that's what we're using natural language processing for, that really unstructured data that we're pulling from the Reddit chat discussions, from Twitter, from Quick Law, from Click Law, from pretty much everywhere that people are investigating their legal problems. We're investigating what they're asking, and we're designing solutions in the second half of our lab to those identified problems. So that's what we're using NLP for. I look forward to a couple of our MDSCL interns that are actually working in the lab joining. But for now, I'll pass it back to Garrett to introduce the next speaker.
Thank you, Lachlan. That sounds exciting. And I know that when I think of law, I think more of lawyers and access. So yeah, some of those examples you got, I was thinking, wow, I didn't even realize that's related to the, or can be considered as a legal problem. So yeah, I'm sure we'll have some interesting questions come up about the work you're doing.
Right.
So our second panelist is Mona Datt, who's an engineer by training. She has a keen interest in data-driven decision-making. With over 15 years of experience in legal and insurance data processing with her first company, eDecree, Mona is very familiar with the value of dark data and its potential to enhance decision-making. She founded Loom Analytics in late 2015 to harness this potential and turn it into game-changing litigation and business intelligence. So Mona, if you'd like to just talk a little bit about your work, that'd be great.
Yeah, okay. Thank you. Hi, everyone. I'm Mona Datt. As Garrett mentioned, I have been running Loom for 6 years now, Started Loom out as an analytics company that was focused on doing litigation analytics in the Canadian space. We provide litigation analytics for everything except criminal and family law. And really my interest was looking at the patterns in court proceedings. So being able to look at historical patterns and then provide a way for players in the justice system, whether it's plaintiffs, defendants, counsel, judges, to be able to use that information to make better decisions going forward, whether it means a lawyer deciding whether to bring a motion or an application to court, or something bigger like, something bigger like how much should they be even claiming outside of court for a private settlement. So those are the types of decisions that court analytics helps our clients make. Along the way, we started seeing a demand for we started actually seeing demand for the system that court analytics was built on, because we were hearing from the legal industry, whether it was in-house legal departments or corporate law departments, that they wanted a way to be able to actually look at their own data and do data-driven decision making, right? Similar to what Lachlan was talking about with their lab, the private sector doesn't have a way to solve these problems either. They're looking at all their matters in isolation, and there's no big picture thinking and looking at the trends. And so Structura, which is our second product after court analytics, was born out of that need. So it's a way for our clients to be able to go in, business users specifically, to be able to go in and build out their own data management and workflow systems without need for IT support. Because for us, the big thing was providing our clients the actual players in the business processes and the legal processes, a way to be able to build their own solutions out without having to rely on IT and additional external resources to be able to solve some of these data tracking challenges.
Thank you, Mona. I know with the Capstone projects the semester, one thing that the students have encountered is a lack of access to data and availability to data. So I think they'll be interested to hear anything you have to say about what kind of data is being made available. So our third panelist is John Kahn, who's a lawyer and a PhD researcher and course instructor at Osgoode Hall Law School. His research expertise is judicial decision making, judicial independence, written judicial decisions, empirical legal research, and using human-centered design and legal reform. He holds a BA in history and philosophy from York University, an LLB from University of Ottawa, and an LLM from the University of Toronto. So John, yeah, if you can talk a bit about your interests, that'd be great.
Well, thanks for having me, and I'm really excited about the program that you have put together there. It's really fascinating to see kind of the interdisciplinary approach to trying to solve real-world problems. So just picking up on something I think that Lachlan said in terms of access to justice, we hear this word a lot in the legal community and how people define it as kind of fuzzy. Some people have different views about what it means, but regardless of how people define it or the ways they want to say it should protect Canadians' right to be able to go to a court or solve a problem, I believe that a lot of these things are actually empirical questions where we should be able to have a transparent empirical answer about, do we have success in our legal system? What are some data-driven metrics where we can look at the speed or the accuracy or the predictability or the cost effectiveness of our legal system? So when I started looking at this, I started realizing that access to justice is a huge myth in Canada for most people, but especially for racialized, marginalized, or Indigenous people. And despite this clear reality, we really don't have the data to go out and try to measure or try to actually have data-driven solutions. I'm sure we'll talk to it a little bit more, but we have a huge data deficit in Canada. And a paper that Amy wrote with her co-author Jenna McGill, they talk about how we have, quite a bit more insight about baseball and sports than we do about our legal system, and that's a huge problem. So what I try to do in my research is to develop ways of using NLP to parse existing information from dark sources. Specifically for me, I look at judicial decisions and then try to use that data using random forest modeling to make some high value predictions about the ways in which judges output long decisions or complex decisions or slow decisions or decisions that are frequently appealed, to try to say to reformers and regulators, here are the things on a statistical basis, and here's some predictions about potentially some high value things that you should be pursuing for reform. And then I use those as well in my research to try to suggest some data-driven empirical reforms.
Great. And I mean, as much as I am a big baseball fan and a fan of having access to baseball statistics, I can definitely see the importance in trying to get, I think in the big picture, legal access to legal data and being able to process this is much more important than knowing which hitters are hitting well on Tuesday. So thank you. I expect we can touch on those topics a bit more during the talk. And our final panelist is Amy Sellison. She's an associate professor in the Faculty of Law, Common Law section at the University of Ottawa, and a faculty member of the Center for Law, Technology, and Society. She received her JSD from Yale Law School for a dissertation exploring judicial regulation of lawyers in common law jurisdictions. She also received her LLM from the Yale Law School and her JD from the University of Toronto. She's written extensively in the area of legal ethics, lawyer regulation, the use of technology in the delivery of legal services, and access to justice. Amy is currently the president of the Canadian Association for Legal Ethics. So yeah, Amy, if you just want to say a few words, that'd be great.
Thank you. Thanks for having me here today. I think, kind of exactly as you signaled in your introduction, where I come from these questions, I have my broad area of expertise is on something called legal ethics, which looks at ethical obligations of lawyers. And then I also look at regulatory issues in the delivery of legal services, and a bit of judicial ethics too, so behavior of judges. So safe to say, compared to our other panelists, my approach comes from a less hands-on perspective, kind of looking at policy questions and normative questions from kind of a more removed distance. In terms of some of the projects I've been working on recently, one thing I've been doing is helping to develop guidance for lawyers about how to meet their ethical obligations when they use technology. So, data security is a huge one, but also thinking kind of proactively, like, is there an obligation to use automation? What about AI? There's lots of questions there, of course. If a tool provides the lawyer with an answer to a question, how do they do the due diligence? So, there's a recognized obligation of lawyers to supervise people who they delegate to, but how do you supervise an AI tool? How do you translate that obligation? And so there's a lot of interesting questions around that. A second area in terms of legal technology is looking at what I call direct-to-consumer tools. And so looking at tools that don't engage with lawyers, but look to provide people with solutions to their legal problems or questions directly, so without an involvement of a lawyer. And so, for example, in Canada, we have a large number of apps or digital tools that can help people create wills. So that's an example of something like that. And so developing, kind of tracking what tools are available. There's also big regulatory questions that arise because the law societies regulate legal services and have traditionally only really allowed lawyers to do that. So sometimes historically, they've gone after some of these tools. Now we see more openness for innovation, some what they call regulatory sandboxes opening up. Also do some evaluation of those tools. And we're doing a project with Clio in Ontario, who's developed guided pathways for family law and looking at that through a lens of functional literacy. And then finally, back to something that John had mentioned, one particular tool or type of tool I've looked into and written about in more detail is something called judicial analytics. So, back to what Mona was talking about, providing information about patterns in judicial behaviors and kind of some of the systemic implications of that, both the benefits and what could be some of the risks areas. So I think that's everything I have on my kind of brief point form, and I'm happy to answer any questions about any of those topics and looking forward to the discussion.
Yeah, thank you, Amy. I know I definitely perk up when I hear the aspect of ethics with relation to AI. It's definitely an emerging field and an emerging concern. It's no longer just the point, or at the point where we can just we have our data, we'll run a machine learning model over it, and don't worry about the implications. It's a very touchy subject and a very important subject, and I can imagine with legal data, it's even more so, just because there are so many implications and so many important results that come out of these systems. So now that the audience has met our panelists, I'd like to just start off with a question, I guess, as to the current state of legal analytics in Canada, or in Canada in particular, but in general. So I haven't worked with any legal data in the past. I don't know what kind of data does exist out there. And you did touch upon this a little bit in your introductions, but what kind of data is there available to train models on? What models are available for topics such as access to justice or giving recommendations to lawyers or judges? What exists out there? So I'll open it up to our panelists. Anyone who wants to pipe in on this topic would be great.
I'll start from the commercial aspect, right? There is data available, and up until recently, it wasn't available in bulk. We would have to go back to CanLII and download the data there. There's been concerns there because CanLII is not required to really provide commercial access to legal tech companies. So there's been challenges because there's really no there's been no thought given yet to a way for tech companies or even research projects to be able to access data in bulk, right? That said, there is now the Lidi Compass Law Initiative by Colin Lachance, where he's trying to bridge that gap and taking data in bulk and providing it for universities, for legal tech companies, for law firms that want commercial access to it, or in the case of Lidi, research access to it, that's available. So that's changing now. That's one piece of it, which is having access to the data to begin with. The other part of it that becomes challenging is discretion to publish. So in Canada, judges have discretion to publish, which means they can decide whether or not they want to publish their decision. And when you are looking at being able to build predictive systems, statistically, you either need all of your data or you need you either need all the decisions for a given jurisdiction or a given practice area, or you need a completely random sample.
Yes.
But with the discretion to publish, you don't have all of it, but you also don't have a random sample.
No.
Because some judges publish everything, some judges publish nothing, some judges decide what they want to publish. So there's two sides to this that become challenging and completely impact, at least from a commercial perspective, what we can deliver to clients.
And if I can follow up on that, why do judges not decide to publish their decisions? I know this is just kind of maybe interpreting and trying to guess why they might do that, but
I think that's John, right, John?
Historically, judges didn't publish reasons at all. It wasn't a huge part of the common law. And then through time, judges started publishing more and more reasons. And you see the Canadian evolution peak after the charter, where judges started publishing more and more decisions. But I think we have this intuition that every time a judge makes a decision, they write it out or they give oral reasons. And if you go back and you look at the history of the common law, you actually see stuff from our own Supreme Court basically saying stuff like judges shouldn't offer transparent reasoning about why they came to a particular decision. Just make their decision and move on. So I think we now see judges publishing a lot more than they used to, but all the problems that Mona noted. One of the things I think that bears mentioning about data is that obviously decisions the judges write are one form of data, and then there's all the kinds of data that Lachlan's dealing with. But just generally in Canada, our approach to kind of aggregating or even collecting data about the court system has been really slow in comparison to the UK or aspects of Australia, New Zealand, and especially the States. And why that is probably because a lot of courts don't have the autonomy or the funding to do so, but we also just haven't had the same data-driven push in Canada. So not only can you not access data in a lot of bulk formats, but in many others, like we don't in Canada know what the national divorce rate is. We don't know what the national guilty plea rate is. It's just not tracked. So that's the other thing that we're starting to see more of now, or at least conversations about what should we be tracking, because some of what's tracked by StatsCan, for example, is not really amenable to any modeling or analysis.
So if it hasn't been tracked, and I know this came up in previous discussions, are decisions based on previous information as they currently stand currently incomplete, or are they just based on partial information? Like when a judge makes a decision based on precedent, if it's not tracked at all, are they making it based on a partial precedent, or are they like? I guess what I'm asking is there missing data out there that if we started tracking, would we all of a sudden have all access to all the data if it all became tracked in some database or something that lawyers and judges could have access to?
Maybe one thing maybe that might be helpful is maybe add, not to complicate it further, maybe even add some more layers and just, I think, as I've studied this area, I keep on learning more and more about how things are actually done, and even practicing lawyers don't get a sense about how some of these things work. So I think, just to add and reinforce what John said. So I think, you have someone in a courtroom and the judge in a proceeding may make a variety of decisions, may even make final determinations. Some of those may be oral. So, how are those tracked? Do people have access to transcripts? So that's a huge issue in Canada. And I mean, generally right now, and John and Mona can correct me, or Lachlan, there can be a right to access, but it's highly expensive. So it's not like you can just plug into some kind of public database and pull up these transcripts. Then there's a question of, does the judge reduce something to writing? When I practiced, and it wasn't in ancient days as a litigator, in a lot of my cases, a judge would just write their decision on the back of your written brief that you submitted to court. And that was the judge's decision. You photocopy that, and then you type up an order based on that. But that's not getting kind of put anywhere, so to speak. Then there's a question that maybe a judge goes back to their office and types it up in Microsoft Word, and then, gives that to the parties. Does that get published on the court's website? Maybe, maybe not. And again, John and Mona can talk about the stats to that. And then there's a further question. Can third parties gain meaningful access to something, even if it's published on a website, in terms of access to bulk data? And I think some things are shifting there. Then there's a whole other question of, a decision is reached, you have kind of the judge's explanation, but you also have the written submissions of the parties, testimony of witnesses, all the things that go into a court record. And again, we haven't really seen much digitization of that information and or open access. There's a lot of competing questions when it comes to this in terms of, privacy interests of people involved in the court system, and, questions as to whether or not there's a meaningful difference when you remove what they call that practical obscurity of having to go trudge down to a court office and ask for the big paper file versus a click of a button. And there's been some issues of third parties kind of holding people's court data for ransom, so to speak, that I think has given people a lot of reticence about that topic. And so, yeah, and on the flip side, I think, just as John signaled, if we are operating in a democracy, understanding what's happening in our courts is essentially, very important. And it's just really shocking the degree to which we don't have access to data. So that's kind of my 2 cents, kind of from the kind of policy perspective on the issue. There's a lot of things that we don't have.
Yeah, and it's interesting because it's not just a policy issue; it becomes a workload issue. If you're not publishing, even forget the reasons. If you don't publish reasons, you just give a decision. It's subject to appeal. Automatically, you have an opportunity to appeal it because the judge hasn't actually justified it, right? So more people will appeal these things, right? And so you're clogging up the courts there. But beyond that, if you don't even have basic statistics about whether a motion or an application is a slam dunk or not, and people are operating in under the misconception, like the plaintiffs, the defendants, the lawyers are operating under the misconception that they have a valid motion because of the published body of law. Meanwhile, the judges in their mind are thinking, what are these people doing bringing this motion? And there's that disconnect. So you've got more motions and applications being brought that just keep getting tossed out. It's creating more of a backlog. So it's almost like this vicious cycle of I'm too busy to write decisions, but because I'm not writing decisions, I'm getting more and more showing up in my court.
So coming at this from a data science perspective, when I originally thought or started working with Ryan to put the panel together, I was thinking, oh, great, we have access to all this data and we can start training our models on it and start helping with systems. But it seems like there's a real problem even with the data that does exist being horribly biased, as you said, Mona. And just the fact that there is so much data out there that isn't in a format that we can even start to use it for digital systems and digital algorithms. So I guess, would a first step solution be to try to digitize a lot of this existing information? I know, Amy, you mentioned that there are privacy concerns and with all of a sudden putting everything in a centralized database that what did you call it, Mona? The obscurity of access to the data, of having to go several steps all of a sudden is removed when you do have just the access in a database. So I guess I'm asking, would it be reasonable to try and create a centralized database where this information is available to anyone who requests it?
Yes, there are some provinces and some court levels that are at least starting with eFiling. That's a start. So that's a start for putting a stake in the ground and moving forward, at least to have digital records. Then you've got to solve the data anonymization and sanitization process where there are privacy concerns, and so you need to be able to while there is a significant benefit to making the data available for driving policy, driving tech, driving data science initiatives, all of that, there are several steps there, right? Like and I think that part of that has to be with the courts. There has to be this push, this drive that says it is important for us to, and it comes down to really, John is right, like, yeah, in the ancient times, nothing was published, right? Like, but really moving forward and looking at it and saying, we want to get to a certain point 5 years down the road or 3 years down the road and saying, let's create a project out of it and say, what are the different pieces we need to put together to get there, right? And one of them is e-filing. The other one is, if you want to do a look back and go and scan every single record that's sitting in a courthouse somewhere, you can do that. But then it becomes expensive. It becomes cumbersome. Who's going to do it? Then those are barriers that go up. But even if we said, forget everything from the past, let's just move forward, that's still a good start.
Well, and you mentioned the cost of going back and recording it. I can't imagine, though, that the cost of not having access to this data is less than the cost it would take to actually make it available. Like
there's paper copies of statements of claims sitting in some courthouses.
Mm-hmm. Yeah, something that I actually used the MDS CL students for in 2020 was I got them to analyze 5,000 negligence decisions. So every BC first instance court, every time they handed down a decision that related to a particular cause of action, which is called negligence. And I basically wanted to work out how much the courts were awarding people. And for me to get that 5,000 cases, they weren't on Canly. Canly didn't have that many of them. They weren't on Westlaw or LexisNexis in a file that I could download them in, batch 500, 1,000, 5,000 at a time. So it was such a challenge for me to be able to even access that basic court decision for those decisions that are actually written and recorded and published and given to a legal publisher. It was such an elaborate process for me just to be able to access those so that they could be analyzed, that we came up with some pretty cool results, but it was really labor intensive just to do one small study for one small journal article.
Yeah, go ahead, Amy.
Just quickly on the cost issue, this is something that all my other panelists will be able to speak to, but I just wanted to raise the issue of legal decisions being unstructured data. And historically, that has been, a huge cost barrier to developing any type of analytic tools because, and I think the technology is changing. I'd be interested in hearing from, our panelists, but, historically, if you're going to, build some kind of analytics tool, you would have to have essentially human people coding and going through the decisions. And I know Mona did that for her, and I'd really like to hear about that. And John referenced an analogy I used before, and one of my favorite analogies that John uses is it's not like a medical record where you have kind of, patient name, symptoms, diagnosis, and you have these fields, you can just plug it in. I'm sure there's also challenges with that in terms of terminology being consistent, but, I train law students about how to read these decisions, and, even lawyers can pull up a court decision and have no idea what the court actually decided. So you have huge issues, and even simple things like inconsistency in how, language or terminology is used, but, it's not like, here's a judge and they have the facts, reasons, and decision, and you can just kind of plug it in. And yeah, I'd be interested to hear from the panelists the degree to which natural language processing has been changing that. And I know there's new techniques out there, but I know, Mona, when you were starting, that was a huge.
Oh, we're still doing it manually. We're still doing it manually because we're building out the training set to be able to automatically, and it's getting better, where we can at least identify phrases that refer to certain practice areas and stuff. But we essentially have to combine a few different NLP strategies to come up with something that can come close to a human being. What we normally do is we start with a decision. We have to zone it into three parts. The first is the SOC that sits at the top, right? Like that block before the text, the actual grammar starts, right? The language starts. So it's the names of the parties, all of that. Then we've got the paragraphs. So that's zone 1. Zone 2 is the actual decision. And then zone 3 may or may not exist in some decisions where sometimes you'll have the name of the judge just in zone 3, or you'll have the names of the lawyers just in zone 3, right? And so that's one part of it. And then we go in, and for zone 1, we do entity recognition. It may or may not work. Sometimes, because I don't know about some other provinces, but Ontario, very often, more often than not, it's first initial last name. What do I do with a J. Smith? Whether it's a judge or a lawyer, what do I do with a J. Smith? And then there are some situations where they'll have full names, but it's the same first name, same middle initial, same last name, same practice area, sitting in Ontario. We have 2 personal injury lawyers in Ontario. One sits with Beerwinter and one sits with McCarthy, who are in personal injury. Same first name, same middle initial, same last name. The only way we were able to figure it out is by looking at their co-counsel to see which firm they belong to. Right? It's in some cases it's an exercise in futility. You're sitting there going, this is so expensive. Now, if I were to compare that to Pacer, right? In Pacer, for those of you that don't know, Pacer is the US electronic record system for justice. And all their federal proceedings sit on there, and quite a few of the states are starting to move on there as well. The lawyers got an identifier, like an actual digital identifier that ties it back. So there was an initiative back when in the 80s that was started where the government made an investment and decided that this is what was needed. And now it's just on autopilot. Right? It's things like that. It is extremely expensive. I cannot even begin to describe it. And yeah, we have two stages of data extraction, the non-legal and the legal. So we've trained a data entry staff to do the non-legal data extraction for zone 1 and zone 3, and zone 2 is law students, where there's this list of things they've got to pull out, and what defines, like you said, sometimes lawyers can't tell whether a motion was dismissed or agreed upon, right? So we have language that tells somebody reading the decision what it means. And so there's this lookup table to interpret a judge's language, which to me is shocking, right? If that's the state of a judge's decision, what hope do we have? If a lawyer can't tell, what hope do we have that a self-rep or a non-lawyer looking at this can actually figure this out?
Well, you mentioned, Mona, that you sometimes do use NLP tools and that they don't always work. This is a kind of a vicious circle that we have in AI in general, is that we don't have tools to begin with, so we kind of borrow one from a different domain, different field, try and apply them. They don't work. So often, what we end up having to do is we end up having to do a lot of annotation at the start and build up tools for the specific domain in order to get reasonably accurate tools that can do a little bit of annotation, and then it reduces the annotation load for the experts. They basically resort then to correcting the mistakes that the NLP tool is making, and create better and better tools down the line. But this process takes years often to get going, and the fact that we don't even have really legal domain data to train these tools on is a real significant issue. That it's a place that people are often very hesitant to start up in, because it is so expensive to start up and to get going. And I'm not sure if there's another viable solution other than starting to record this data and get it into a format that can be used to start building these tools. I don't know. Maybe John or Lachlan, you have a bit more experience with working with the legal data. You have an idea of kind of how successful these tools are right now.
I can speak to my experience. It definitely was a challenge to be able to appropriately annotate all of the cases. We had to annotate, the students had to annotate a lot of cases. It was quite labor intensive, and it still meant that we were interrogating the 5,000 cases for a wide variety of things. And some of those things just didn't work. The annotation level just wasn't at a high enough level to do that. But some things it worked okay. So I think it's a question of what's an appropriate task to be given to the NLP model, because some NLP modeling is just asking for too specific of a question. And when you're dealing with such unstructured data, you almost need to annotate every case, which is obviously defeats the purpose. So it can work, but you've got to train it to specific useful questions rather than trying to train it to respond to every potential answer.
I think, I've talked to some people who on particular tasks, they're getting really high, F scores, like well above 7 and getting, or 0.7, and getting really good kind of crisp responses to what they're looking for. But then I think, as Lachlan said, there are all these other issues where you try to think, okay, we could have a tech solution for this, and it just doesn't work because the data is so messy. But I think I'm pretty optimistic that if it was kicked open wider, because you see what happens sometimes when a hackathon gets something for 30 hours, like a dedicated group of people actually trying to attack something. And this circles back to a point, I think, that you made earlier about why are we kind of at this place. And I think Amy and Lachlan speak to this far better than I could. But I think part of it deals with the lawyer's monopoly over legal services. And I think if you start kicking open access to judgments and legal data and legal information, you're going to have a bunch of tech entrepreneurs who say, well, I can do a divorce for $500, or I can do, a will. And actually in BC today, the first application to the regulatory sandbox was an online will company. So I think they're going to be, if it actually was kicked open, I think we could start to solve some of the NLP problems through hackathons, but then we're going to see all this host of other things where people who don't know that they have a legal problem, this is a lot of what Lachlan deals with, could go and use one of the various apps that exist in the space, which Amy could speak to. But then you're in this blurred line of, well, is this tech company providing legal advice and information, or are they providing a legal service? And I think part and parcel with resolving the data point and access to data, law societies and governments also have to at the same time say, what does a legal service mean in 2021? Because it doesn't mean what it meant in whenever, when we decided to create this, exclusive group of lawyers. So I think part of the exclusivity and lack of data tracking is probably tied to the monopoly over legal services, which really, as I said, I think Amy and Lachlan could speak far better. But everything I've looked at says we have to have a serious conversation about that, because you could have engineers creating really simplistic, accurate solutions for people that would cost way less, that would alleviate a lot of the problems in the legal system generally.
Yeah. So to maybe add, and then people may have varying degrees of familiarity when we talk about lawyers' monopoly. So essentially means, with some exceptions for paralegals in Ontario, that it's illegal for anyone or any technology essentially to provide a legal service if they're not licensed as a lawyer. And so there's also been a big debate and lots of fights about what is legal advice versus just providing legal information, which isn't regulated. And historically, in North America, law societies have been very aggressive about prosecuting, some innovative companies who have tried to do things, even like form builders and things like that. Now we're seeing a bit of change in approach, I think, and we've referenced these sandboxes that have come up in BC and Ontario. And what they're saying essentially is, we'll basically suspend the application of the rules for people who want to try these, non-lawyers who want to try these innovative ways of delivering legal services. We'll monitor it, and then maybe we can change the rules after we've done that. So that's been a huge issue. At the same time, I've written about, we talk about tools, not tools used by lawyers or judges, or within the judicial system, but the tools used directly by the public. There are some concerns that, justify some entity regulating. So if you think about when someone's involved and has a legal problem, it's very much going to depend on the type of legal problem, but some legal problems involve very sensitive information. And you want to have some kind of understanding about how the person's data is going to be used, actively or passively sold. Lawyers have what's called a fiduciary obligation, where they need to have loyalty towards their client. There's certain things they can't do. If you look at kind of dark patterns, marketing, there could be a lot of different things. Quality of services, legal services are what the economists call a credence good, where people can't really easily evaluate, are they getting good advice or not? Are they being upsold on a will? They say they need a $1,000 will when they only need a $200 will. So there's quality issues too. I think on the other side, people say, well, there's a whole variety of quality and ethics in the lawyers that are providing legal services to the public, and we don't necessarily do a good job regulating them. Why are we putting a higher standard on technology? But there are those competing public values. Doesn't mean we shouldn't have those tools out there. And it doesn't mean that the regulators of lawyers should regulate these tools. But I do think I take a position, not everybody does, that there are some reasons why you might want to regulate the provision of these types of tools.
All right. Thanks, everybody. I'm going to take a moment to pause and just ask if the audience has any questions that they want to ask our panelists.
When people are doing that, can I just give a shout out to some work that John's done that we haven't had a chance to mention? And hopefully I'm not going to misrepresent it. But talking about the issue of access to data and the challenges in making it usable, I think something interesting that John's looked at is kind of dealing at the situation at the front end, so kind of accessibility by design. Should judges much more standardize how they write opinions, to make them more machine readable, but also to make them more readable by the public? And I think there's been some organizations and reports talking about the need to do that. So maybe there'll be some movement towards that. But I think that's really important work. So there's kind of two ways of tackling the problem. You can kind of make the technology better at reading confusing decisions, or you can make the decisions less confusing at the get-go. And John's LLM thesis dealt with that, and it's really excellent work for people to look at.
So I see we have a question. And maybe John, we can come back to the question of access. But I do see a question about Would like to hear panelists' thoughts on AI and ethics. So one thing I was thinking about when we were talking about maybe having data accessibility was we all know of data leaks, and then privacy issues become a big concern. But I'm just I'm interested and Verada's also interested in hearing your thoughts about AI and ethics.
Good. I could take that's a big question. A good one.
Yeah. It is.
One thing I find helpful, and I'll just be really brief because I know we don't have too much time left, is to think. I think you need to, when you're asking that question, sometimes the question changes depending on where the technology is being used and who is the user. So, there's the different issues that arise when an AI tool is being used directly by the public to answer legal needs. There's different questions being asked when a lawyer is using a tool. One thing we haven't talked about today are tools embedded in the judicial system. So, for example, there's a very kind of notorious example of an algorithm being used to make bail decisions or parole decisions in the United States and relying on past data and basically achieving discriminatory results. And so that's been a big concern. The other concern in the judicial system is transparency. So if you have basically part of the decision that used to be made by a human now being made by a machine, how can people understand how their rights were determined? How can they appeal those things? The explainability issue, even though explainable AI is a controversial term, those are the kinds of things that arise. But I think it's helpful to kind of think about, even when you're talking about legal technology, the ethical issues, I think, really change depending on, what exactly the user is of that technology.
And it's interesting because Amy, the whole bail thing, right? There have been situations where software companies provide bail tech, defense lawyers ask why the bail decision was made a certain way, so they want actual access to the algorithm, and the software companies come back and say it's proprietary tech, and that's how the appeal is actually blocked. And it's actually happened at least twice in the US in the last few years, right? And then if you took that to a different industry, Amazon and its HR decisions where they have to start pulling down their automatic NLP-based resume analysis for engineers because their data training set didn't have as many females in it. And so it was rejecting a lot of female applications. So there's two sides to it. One is the training data, and is your training data actually biased? And the other side is, are you using it blindly without using the judge or the decision maker as almost like the human touch? And so that the tool is being used to assist the decision maker in making decisions, but the decision maker should still have some discretion, right? Because there might be circumstances that impact their decision that are not addressed by the tool.
Yeah, just a 30-second point here. I think that's super important as well. I think when people talk about AI and ethics in the law, we're always talking about a prospective or predictive basis. But I think ethically, the legal system has an obligation to use it on a backwards or reconnaissance basis, where you're actually looking for, in a data science sense, what are the standardized biases, not in a racial bias, what are the standardized biases and what are the standardized noise that we can identify? Because right now, every lawyer and most people know it, but we don't have a standardized way of looking at it. So ethically, I argue that I think judges and courts actually have an institutional obligation to use tools that say, where's the bias and where's the noise?
Yeah.
So I see there's a related question as well about your views on the use of chatbots for providing legal guidance. What are your views on, I don't know, we talked a little bit about what exactly constitutes legal guidance and what level, but if you have a chatbot that is recommending certain paths and it's kind of treading that gray area, what are your thoughts on these types of systems?
So for me, I have a commercial interest, right? And so to me, why not? Why not? If a lawyer feels that their domain is being encroached on by a machine, then the lawyer's got to think about why is it that the machine can do their job, right? The lawyer is there to provide that perspective, that additional layer. And to be honest, if somebody's going to a machine, if they could have afforded the lawyer, they would have. So that lawyer hasn't really lost business, right? That machine is there for people who actually can't afford lawyers. Right? And in terms of do not pay, their genesis was parking tickets. Since when is allowing a customer to pay parking tickets a legal domain? It is so simple. Right? So from a commercial perspective, I would say, why not? If it helps people solve their legal problems, why not?
I think to that, I just maybe, there's a question about whether or not, that should be banned. I think it's also a capacity question. And I think if you, look at what do not pay does, it's not providing legal advice to someone who's been charged with murder, right? It's helping people cancel their subscriptions, challenge their parking tickets. It can do small claims courts. And I think, Mona's exactly right. It's actually not even that people can't afford to pay lawyers, but it doesn't make sense to hire a lawyer. Like if you're fighting with somebody about canceling your subscription or getting a refund because Amazon delivered your box late. So I think they've been very effective, addressing consumer rights issues, as far as I can tell. And that's been really exciting. But, I think, what a chatbot can do does still have some significant limitations, I would say. And you wouldn't want just anybody, having some criminal law chatbot out there dealing with people's, criminal needs, I would say.
Yeah, so there are certain narrow use cases, and they do it very well. Sorry, Justin.
I think Lachlan could probably speak to this quite a bit better as well, but a lot of what the Better Justice Lab does is deal with unmet legal needs. So maybe a chatbot, you could have an interaction where the chatbot says your course of action is to go and talk to a lawyer, but I'm sure Lachlan has some thoughts on that. Sorry.
Yeah, the man who actually asked the question is one of our Better Justice Lab interns, and he's been quite amazing. So he's sort of asking that because that came out of an opportunities document that was generated as a result of his work. And that's actually something that we're going to operationalize in the fall. We're going to integrate a chatbot into Reddit so that when people are going to Reddit, like r/Legal Advice Canada, and then going to the subreddit of looking at BC, if they're asking questions to which there are answers, the chatbot can pick up that question and say, well, there's a resource that can answer this question. Here's this resource. And that's one of the useful purposes to which chatbots can be turned. I agree with Amy, should I respond to this bail question? Should I plead guilty to this criminal offense? Those sorts of things you sort of need legal counsel for, and the chatbot's maximum utility there is to say, go get a lawyer, don't ask me this. So chatbots, if they're appropriately circumscribed, can be done ethically and quite usefully, and do not pay is an interesting example of something that's been expansive and has reached some success.
Yeah, and for us, what we're looking at is taking a simple chatbot that will allow legal aid clinics to support their client base for simple form filling, right? Allow them to fill out their ODSP claims, their maybe their landlord tenant board forms, things like that. That it's two parts to it. One is giving them the opportunity to do some of this themselves, and then even freeing up your legal aid resources, like from an operational perspective, to be able to do more hands-on work versus working with them to just fill out forms. So you can, your client can come in with all the information already filled out, and all you're doing is verification. So there's the benefits of streamlining ops with simple chatbots as well. If the lawyers are worried about, turf fights and stuff, there's opportunities to do it in an assisted way.
Okay, I think we're almost out of time. So I'd like to thank all of our panelists for some very active discussion and some very nice discussion of the current issues that are maybe preventing the legal data and legal profession from working together with with data scientists, and maybe how we can start working together more closely in the future. So please, thank you to our panelists, and I enjoyed this discussion very much.
Thank you.
Thank you.
Thank you.